Today's presentation will last about an hour, and you will have the opportunity to submit text questions to today's presenter by typing your questions into the questions pane of the control panel. You may send your questions at any time during the presentation. We will collect these and address them during the Q&A session at the end of today's presentation. I want to thank the State Bar for sponsoring this program and for their support today. And now I want to introduce Henry Evans. Henry is the founder of Evans Law PC, located in Sioux Falls. He is a graduate of Hamlin Law School and is admitted to practice in Minnesota and South Dakota State Courts, South Dakota District Court, and the Cheyenne River Tribal Courts. Henry is an involved member of the American Immigration Lawyers Association, the South Dakota State Bar Immigration Law Committee, and the Real Property Probate and Trust section. Henry is also a member of the ABA and Rotary International. And with that, here is Henry for today's presentation.
Hey, thank you, Jeff, and thank you everybody else. And if someone has a question, feel free to ask it. And I've modified the handout a little bit, which was sent through the State Bar. But first, I'm going to start about what branch of the federal government influences the application of the Immigration and Nationality Act, or what I'm going to refer to as the INA. Immigration law is an example of administrative law in many ways. And one way it's an example of it, there are many different achorisms. And the INA is the achorism for the act. And when Congress, I don't know if Congress is the right word there, but when our country formed our Constitution, which is asked about in different ways and shapes and forms when a person applies to become a naturalized citizen as the supreme law of the land, the Constitution basically established Congress and authorized Congress to establish a uniform rule of naturalization throughout the United States. And that is in Article 1, Section 8, Clause 3 of our Constitution. But as we know, with the checks and balance system that we have in our country, Article 2, Section 1 basically gives that executive power to the President of the United States, and the President is vested with enforcing the immigration law. But Congress, as we know, may appoint inferior officers and officers to do stuff which the President alone has. And the President has the head of the departments. So where we go with this is that within our current system, 4 different agencies influence our immigration law. The first agency we're going to talk about is the Department of Homeland Security. And the Department of Homeland Security is a product of 9/11. And within Homeland Security, along with the TSA that we encounter at the airport, we have the United States Customs and Border Patrol, which before Homeland Security came about was part of the Treasury Department. Then we have Immigration, Customs and Enforcement, which is the enforcement side of immigration, and they enforce and investigate immigration matters within the United States that don't occur necessarily at the border. Those issues are enforced by Customs and Border Patrol. And then the third branch we have, or sub-agency we have within the Department of Homeland Security, is the United States Citizenship and Immigration Services. That agency issues all immigration benefits, such as naturalization, or possibly, employment authorization document. The second agency that we have would be the Department of Justice. Within the Department of Justice, before Homeland Security was created, the Department of Justice had 2 sub-agencies that enforced immigration law. It had the old legacy Immigration and Naturalization Services, which ended because of Homeland Security Department was created. The second sub-agency within the within the Department of Justice is the Immigration Court, which is formerly known as the Executive Office of Immigration Review. And I want you to put a star next to the Immigration Court, because as we get more into this topic of who wants to be an American, the Immigration Court is going to take an interesting role on how it influences immigration law, but more importantly, immigration policy. The third federal agency which influences immigration law is the State Department. Because if one is outside of the United States and they want to enter the United States, they're going to need a permission slip to enter. And that permission slip is called a visa. And visas are issued for different purposes. An immigrant visa is issued for when a person is going to be immigrating and remaining in the United States as a permanent resident. The term permanent resident is also known as a green card holder, because originally and at one time, permanent residents had their residency cards issued on green paper. The fourth federal agency, which is involved in the influencing and the enforcement of U.S. immigration law, is the U.S. Department of Labor. For certain types of work visas and certain types of employment situations of hiring somebody who may not be either a U.S. citizen or a lawful permanent resident, the U.S. Department of Labor has the authority to determine the wages as to what that non-U.S. citizen or non-permanent resident, or sometimes is called a non-immigrant employee, will be paid. And the last administration, President Trump's administration, truly influenced all these different branches of our government, which enforce and afford U.S. immigration benefits. And before I get into the political melee between these two administrations, I just want to give you a sort of history of our immigration law, so that way you know how we got there and how we got from 1790, which the first Immigration Act was passed, to 2021. And basically, Congress decided, and the President Washington decided, that since the term citizen is not defined in the Constitution, the U.S. government needed to define what exactly a citizen is. And that's one of the reasons why Congress implemented the first act. But the Constitution does define a citizen as a free white person, but it doesn't define the criteria as to how one becomes a citizen. And historically, Congress has delegated its authority to create immigration policies, and more importantly, to create immigration law, to other entities. And the nativist movement of the 1840 anti-immigration attitude did not really materialize into federal legislation. That was kind of the do-nothing movement. But they manifested in discriminatory local regulations and statutes. In the materials, I cite the U.S. Supreme Court case of Wu versus Hopkins, a 1986 case that found a San Francisco ordinance prohibiting Chinese Americans from using laundromats as unconstitutional. But the interesting part about that case is it wasn't a federal law that was being litigated about. It was a city ordinance. And you can see further examples of how state legislatures or local authorities have been the subject of immigration enforcement policies because Congress has not really taken the bull by the horn on this. In 1995, you had the California Proposition 187, and that was determined to be unconstitutional. And we've had the more recent Arizona law, which was determined to be unconstitutional, except that local law enforcement has the authority to check the immigration status of a person. The most recent immigration change we've had in our law occurred in 1996. And at that time, President Clinton was our president. And I don't know who controlled the Senate or not, but Newt Gingrich may have been the Speaker of the House at the time, but they implemented our current immigration law of the day, and it was called the Illegal Immigrant Reform Immigrant Responsibility Act of 1996. And in there implemented the harsh penalties that our current law has. For example, if somebody overstays their visa or accumulates unlawful presence, which is basically being in the United States without status for 6 months or more, you can't come back to the United States for 10 years without an extreme hardship. Before 1996, if you were undocumented and basically stayed out of trouble, that is not being arrested, worked and tried to feed your family and make an honest living like all people do, if you got thrown into deportation proceedings, the immigration judge would basically afford you a residency status. All that ended in 1996. Congress had made that stuff more difficult. And it's changed that standard around. And Congress implemented a term to how we're going to label non-US citizen criminal convicted people. And that definition, which occurred in 1996, is called an aggravated felon. And Congress gave 26 different examples of what exactly is an aggravated felon. It also implemented that if you're convicted of a domestic abuse crime, you could be placed into removal proceedings at that time. And so what I'm trying to give you is a historical trend that basically Congress, when it enacts legislation, has enacted, for the most part, enforcement policies and consequences. And the reason why I use the words for the most part, because in 1986, President Reagan issued an agricultural worker program, which allowed a lot of undocumented people who worked in the agricultural sector to become permanent residents. And where that historical trend has meaning is that President Biden and people in the House of Representatives have proposed the Farm Workforce Modernization Act. And if that act is implemented, it would offer a pathway to citizenship for undocumented agricultural workers. Sounds very similar to what President Reagan did and the Congress did back in 1986. It's going to revise the H-2A agricultural work program. And some of you may be familiar with the H-2A agricultural work program. You may have clients who are ranchers or farmers, and they will hire an agent or immigration attorney like me or some of the other great people and all the other great people on our immigration committee here at State Bar to bring in temporary ag workers to milk the cows, to plant the seeds, to harvest the crop. And it's going to pose a mandatory employment in exchange for this benefit. The bill also is going to impose a mandatory employment verification through the E-Verify program in agriculture. And E-Verify is a technological process that employers can use to verify whether or not the intended employee has the proper immigration form I-9 documents to show why they have the immigration benefit to work. And the form I-9 is an immigration form and not necessarily a tax form, which we complete when we begin our employment at a new employer. And the I-9 form was a product of the Ronald Reagan 1986 era legislation, which is on that. And on the Form I-9, as you may know, the employee will complete the first part, Part A, that says, hey, this is why I'm able to work in the United States. Here are my documents. Then the employer completes Part B on that. And completing the Form I-9 is its own conference within a different phone call. But under the E-Verify process is a database which will allow the US government, basically the Department of Homeland Security, to verify the legitimacy of documents and information that the employee is placing on there. And I keep using the word employee because the employer has to prove that the employee has the proper immigration documents to prove their ability to work up until 3 days after the hire. And it's discriminatory to require those documents before the hire. And returning back to this proposed Farm Work Modernization Act, it's interesting because immigration law can show you the cyclicals of American history. And Arthur Schlesinger Jr., about the same time in 86, wrote this book about how US history is going to kind of repeat itself over and over again. And the conclusions have been made that the Do Nothing Party and their immigration attitudes could be reflective of some of the political attitudes of immigration of today. Not that they don't want to do anything, but that we want to close the borders. And I don't want to tread on any political connotations, so I try to remain apolitical, and it's kind of hard when you choose the most political area of the law to practice within. But an interesting part of our immigration history is that some of the solutions that have been proposed before, but maybe not to the right audiences. And I'm going to use that as the bridgeway to talk about the president's use of executive orders to enforce immigration law. Typically, through regulations that the agencies will create, and for the sake of this conversation, let's use USCIS, Homeland Security. They're going to create different regulations. And at some point, the regulations created will become the implemented law. But along with those regulations, the president has broad authority to use executive orders to enforce those laws. And when President Trump was elected, he used different executive orders to change immigration law. And the same can be said true of all the other presidents before President Trump. And where executive orders became very famous or newsworthy was President Obama's DACA executive order, which stood for Deferred Action Child Admission. And what that executive order said was that deferred action is part of the immigration law. And ICE, if there's certain criteria that's met or at the discretion of ICE, they can give a person deferred action on a deportation order for whatever reason. And I've seen it because the parent might be the single parent to a minor child who's a US citizen, and they don't want to deport that because it would cause an extreme hardship to that child. And I'll give you a case on that, where the mother was from Mexico, child was born in South Dakota, child had a very rare lung disease. And if she went back to Mexico, the altitudes within Mexico would have killed the child. And so the pediatric cardiologist wrote this letter, and ICE did not afford a deferred action to her. I know in the news, they talked about VAWA being passed yesterday in the House of Representatives and the extension of VAWA. VAWA has a lot of connotations within US immigration law. And they're called special immigrants if the spouse of a US citizen or permanent resident is the victim of domestic abuse. There's certain rights or immigration benefits that they can assert through VAWA, but it is through deferred action, metaphysically, that those rights are expressed. And so that's why I just wanted everybody to understand that deferred action wasn't something new. But what President Obama did, which was something new, that said, I'm going to give you a criteria for certain types of children. And they had to be in the United States on this date. They have to have a high school diploma or in the process of getting one, or some type of higher education, which would require that high school diploma, and have really no criminal convictions. And it's harder for one to obtain DACA than it is for one to obtain permanent residency. For example, South Dakota drunk driving conviction, and we're just talking the influence there being alcohol, would disqualify one from DACA, but not another who is applying for permanent residency. And President Obama created DACA because he was unable to get his DREAM Act through Congress. And I believe that was about 2010, right around 2012 or so. And I don't know who was controlling the Senate at the time, but as a result of that, people were lobbying the president saying, and a lot of them were ministers saying, I've got this kid, I've got this young person in my church, they're good, we've got to do something about them, because the DREAM Act would basically allow a process for the child who was brought to the United States undocumented, or maybe the child came into the United States legally, but they overstayed because their parents overstayed, and they become acclimated to the United States. They've lived in the United States. They're just like everybody else's child, except who's a citizen or a permanent resident or non-immigrant, but they just have some type of immigration violation. So President Obama created DACA with the intention that DACA would kind of be a holdover until Congress and the president could work on a DREAM Act. And in the House recently, a new piece of American Dream and Promise Act was proposed. So this is current 2021 politics, bill pending. And it would provide a pathway to citizenship to dreamers. And so the child, young people who came or were brought to the United States as children. But the American Dream and Promise Act would also allow that same path to citizenship to recipients of temporary protected status and deferred enforced departure, who are nationals of countries that were designated for protection due to environmental disasters or civil conflict. So the current administration wants to basically legislate and give a path to citizenship for people that were in DACA. And I'll come back to the other branches, to the other type of people listed in that bill. So let's go back to January 2017. We have President Trump in office. And now President Trump saw how President Biden used, not President Obama, used executive orders. So he had campaigned on a Muslim ban. And the first executive order he implemented was saying that if you are a national of certain countries where the predominant religion is Islam, we're not going to let you in the United States. And that went up to the Supreme Court, and the Supreme Court concluded that he had the ability to do that. And that's one way the president used the executive orders to kind of create an immigration program. And when COVID broke out, President Trump also used executive orders to determine who could enter the United States and who could not enter the United States because of COVID issues. And some of that rationale was very, very medically there, and some of that rationale might be he used to justify an immigration policy to protect the economy. And recently, along with these two bills being proposed in the Congress, President Biden rescinded the travel ban. But another ban that was not yet rescinded was the visa ban proclamation of 152. Now, 152 said that if you're outside the US and you need to come back in to work in the US workforce and you've got a valid visa, we're not going to let you in. Unless if you can prove you are essential to the United States. And I've had clients who've had employees in that situation, and that employee was able to come back. But there have been other employers who have not been that fortunate, and they may have invested in an H-1B visa for a worker, $10,000 maybe in attorney fees and fees to the United States, and the employee decided to return to India to visit family because the employee had not been back to India since he or she left to come to the United States for an education. And because the employee entered on a student visa, which is called an F visa, the student who is now the employee needs to get a new visa in the passport, an H-1B visa. And the H-1B visa program, the previous administration detested. Well, once those visas have been issued, this executive order would not allow the employee to come back due to health reasons and economical reasons. So as of today, 6 senators have asked President Biden to void out that executive order, which prohibits certain types of employees to come in to the United States. And for the record, out of those senators that did that, out of those 5, sorry, my miscount earlier, 4 of them were Democrats and 1 was independent. That was Senator King from Maine. But Executive Order 152, 10052, also put a limitation on the spouses of permanent residents. Another area that the Trump administration wanted to end. If a person's a permanent resident and that person has a spouse back in their country, the permanent resident can file for that spouse. This process is the heart of our family-based immigration system. But this is what some people call chain migration. And the President Trump ran on the thing saying he wanted to end chain migration. And COVID, within this process, allowed him to prevent the spouses of permanent residents from coming to the United States and their children, and used it as a means to modify our family-based immigration system that we have implemented here in the United States. The president also used his executive authority to modify the immigration court. Remember, in our introduction of our federal agencies, I said, let's remember about the immigration court. The immigration court is part of the Justice Department. And under the regulations, the Attorney General can basically overrule an immigration judge, which is part of the Executive Office of Immigration Review, or the Board of Immigration Appeals, which is kind of the appellate court of the immigration law, with a stroke of a pen. And in doing that, at the time, Attorney General Sessions basically overruled or voided out 30 years of asylum law. Because immigration law nuances really don't make easy conversational pieces, the media doesn't always pick up on that. And the Attorney General at the time basically told the immigration judges they have to have a certain quota to finish up so many cases, because the immigration court is backlogged. And it was backlogged back in 2016. This is now March 18th, 2021. I have not been to immigration court since January of 2020, because the courts still have not yet reopened to non-detained hearings. And non-detained hearings is an immigration hearing where the person is not in ICE custody. A detained hearing is where the person is in ICE custody because that individual violated or were convicted of certain laws, whether they were drugs or certain crimes involving moral turpitude or domestic abuse, where they're not entitled to an immigration bond. Those hearings have been going on through the pandemic, but the non-detained hearings have not. So the structure of what does it mean to be persecuted and what constitutes persecution underneath the definition of the Refugee Act was changed by Attorney General Sessions. So if domestic abuse happens in the outside country and the person comes to the United States and claims domestic abuse and the government's not going to do much about it in the home country, that was no longer a grounds for asylum. The Justice Department also offered immigration judges a bonus if they had the most deportation rates as a performance review process. And so as a result of that, and as a result of all these changes, the immigration judges and its union has been trying to solicit an independency, and it has its own independent court system where it's not under the direct influence of the Attorney General, similar to that of the bankruptcy court. One of the more infamous implications of the Trump administration was the child separation policy. And child separation is also back in the news today. Currently on the border, we're going to have a record number of unaccompanied minors coming to the United States. And as the attorney, it opens up some questions, because in the child separation policy, mom and dad came together and then immigration separated them. Or child may have come into the US earlier than when the parent, or vice versa, and they were separated. And the separated child is identified as an unaccompanied minor. And as a UAC, the unaccompanied child, UAC, unaccompanied child, UAC, they have certain rights to pursue the child's independent asylum claim from that of the parents. And this will be the most children we have coming in since about 2014. And I have a client that was entered UAC, unaccompanied child. Her mom and dad had already been here, but she had facts that she saw and experienced and persecution she experienced that was different from mom and dad. And so she was able to pursue her case outside of the immigration court, and we won the case. What's hard now is I have to figure out how to prove mom and dad's cases, because the child's claim of asylum and the granting of that does not automatically transfer to the parent. But the parent's grant of asylum would automatically transfer to the child. And I just wanted to point out, Rule 1.14a said, and this is when you're representing a child, because you would have in the news a 5-year-old child showing up in immigration court without an attorney, and a movement to have that child represented, because immigration court is a civil court. So the right to counsel in of itself does not exist in the civil court unless afforded by legislation. And there was a discussion about that right to counsel. But in preparing for this, I wanted to review the ethics of that child, and that you've got to keep in mind that the capacity of the child that you're communicating with, whether it's in English or through a translator, or if you're speaking directly with that child within Spanish. And you've got to keep in mind Rule 1.4 about communication, and communicating to a child about harsh consequences of deportation or of other matters, whether it's an A and N case we might have, is just, it's a challenge on that. And so I just wanted to present that challenge to give out to everybody. And a lot of the children that I have worked with may have been harmed, witness harmed, or saw harm on their way up to the United States. Another implementation that the Trump administration did was, if you were going to hire a foreign worker, most importantly, a foreign worker in H-1B category, the Department of Labor inflated the prevailing wage. And the policies that we have in immigration law is to protect the US economy. We want to have a policy of immigration saying, we don't want you to come in here to protect our economy. And so what they did on the H-1B visa is that there's always a prevailing wage. So like for a computer programming job, and this is a case that I've got going on right now, the prevailing wage was about $70,000 for the position. But when the US Department of Labor implemented these regulations, that same job overnight went from the prevailing wage of $70,000 to $90,000. So I've got to explain to the employer saying, look, to renew this employee, you're going to have to give the employee a $20,000 raise. And that's why the prevailing wage is there, is to protect the US marketplace and the US worker. But that jump of 20,000 basically shocked a lot of people. And as of today, the Department of Labor announced they're going to take an 18-month delay on looking on other changes to the prevailing wage. The previous administration, interesting enough, wanted to implement a merit system basis and basically did away with the immigration law we had today. And that basically the only family-based type of immigration law that we would have is that if you're a US citizen and you marry somebody who's not a US citizen, that's it. But you can't petition for your parents, and permanent residents can't petition for their family and children, but the US citizen can petition for his or her wife and their children. And what's interesting about that was back in 1964, and I allude to this in some of the handouts I gave, President Kennedy wanted to implement a merit-based system to try to reform our immigration law on that. And in a Wall Street Journal article that I had, and I've got to find the site, and I found it, but Congress gave LBJ a choice. It said either you can have the Civil Rights Act of '64 or this merit-based system that said, hey, if we have a qualified doctor from China or India, Pakistan, you could come into the United States. And we have laws that allow that to happen now, as they did back then, but it's more relevant now. The China's, the clients that are coming in, or the doctors that are coming in from the Far East and Eastern Europe. And Congress gave LBJ the choice of the '64 Civil Rights Act or the immigration reform based on merit. And we all know that he took the Civil Rights Act of '64, which is historical. And I'm not trying to suggest that LBJ made the wrong choice. But what I am trying to suggest is that this idea of a merit system, we have reviewed before. And I think we should review it again as our country looks at immigration reform. And I know there's been a lot of news about amending our state constitution the last week or so. But good ideas do come from the upper Midwest. And I think a moderate type of immigration policy could be there. And I think if good minds get together, legislation could be there where people aren't going to be limited or quotized to come in. But at the same time, the US economy will be protected. The other changes that the Trump administration proposed was he had implemented a poverty and a medical insurance guideline. And before President Trump suggested this executive order and implementation of this policy, one had always needed to prove in a family-based situation that the USC petitioner, United States citizen petitioner, the spouse, had an income of 125% above the poverty guideline for the family size. So if the family size was a husband and a wife, or a husband and a husband, wife and a wife, a family of two, the US citizen petitioner or the permanent resident petitioner had to have an income that was 125% above that guideline figure. And if it wasn't, depending upon who the beneficiary was, the US petitioner needed to have liquid assets. And if in the case of the beneficiary was the wife, that was 3 times the difference between the petitioner's income and the poverty guideline standard. And if the family member was a child or somebody else, then it had to be 5 times that difference. And then at that time, there was a form, and it's still around. The petitioner has to put down his or her income, copies of taxes for the last 3 years. And if the income isn't there, they have to put down the assets, liquid assets, things that can be liquidated very quickly. Stocks, cars, bonds, real estate, things like that, cattle, I've had people use. Well, the Trump administration wanted to make sure that Homeland Security saw that information twice. So they implemented a form of where the person coming to the United States had to complete, identifying who was going to be in their household, whether or not anybody in their household had been on public benefits, whether or not the immigrant coming into the US had ever filed for bankruptcy, and the assets of that person coming in, but also the assets of anybody within their household. So from the practitioner point of view, if I had a client that had an income that was above that 125% figure, we didn't need to really worry about listing assets. But on this new form that the Trump administration created, we had to list those assets. And the American Immigration Lawyers Association estimated an extra hour and a half to 2.5 hours of completing that form. What do you do? Because you want to create a consistent record. So I ended up listing assets that I didn't need to list twice. That form has now officially been eliminated because a court of appeals believes the Second Circuit and the Ninth Circuit found the form to be not needed. And then the current administration withdrew its appeal to the US Supreme Court on the form. So the form was called the I-944. We don't have to worry about that anymore. And so that was a change. And the idea about that I-944 is that I had cases throughout the country where the officer had to figure out how to enforce it. And it just seemed like the only thing the officer really cared about on the form, because it was the simplest, was whether or not the person coming into the United States had health insurance. And if he or she did not have the health insurance, when was she going to get that? Or when was he going to get that? Because that was the health insurance form too. It's interesting. A few days ago, USCIS recognized temporary protection status for Venezuela, and as of today, the 18th, for Syria. And temporary protection status we talked about earlier when I introduced the American Dream and Promise Act, that basically allows somebody to remain in the United States, whether or not that person entered here legally or not to return to their home country because it's too dangerous due to political unrest or maybe natural disasters. And it's a fair question to say, at what point does temporary end? Is temporary has a short-term context to it. And we've had people in the United States who have been here many, many years, decades, within TPS standards. And that was a program or a policy that the Trump administration wanted to end. But it looks like the current administration is now expanding TPS for different people and from different countries, and is recognizing the challenge that says, hey, look, temporary means temporary. So let's pass some legislation to allow these people who have work authorizations, have remained here, have paid taxes, have accumulated equity and wealth, to change their status from temporary to that of permanent resident, and then on a path to US citizenship. One thing that as I include up on, and I am watching the time, is a lot of appointments President Trump had, both on the US Supreme Court and also at federal courts throughout the country. And I will send an updated version of what I created before to the state bar, and the US Supreme Court, and it was Justice Gorsuch wrote the opinion on a criminal case, and it circulated out of the 8th Circuit. And some critics of the decision thinks that it's going to forever harm the modified categorical approach to determining whether a state criminal conviction converts or equates to that of an aggravated felony that I mentioned about earlier or not. In the facts of the case, the person representing the immigrant didn't really make that much record of a crime, except saying, look, in order for it to be convicted, this had to happen, or this had to happen. And the or this part had to happen was basically operating a business or obtaining a business license when you didn't have status to have it. And so therefore, since it has this other choice, though my client didn't do that, he was convicted of the other portion, he shouldn't be deported. And there really, besides that part of the analysis, the Supreme Court ruled said, no, you have to really, when you're doing the categorical approach and you're looking at the modified approach, you have to focus in on the facts of what your client was convicted. And the immigration judges can use And if a good record for misdemeanor crimes aren't there, the immigration judge can use statutory, police records and police records relating to the crime as evidence. And in all the cases that I've worked, typically the analysis that we've always put forward have always been on the provisions of the law on which the client was convicted of. And that was kind of something that kind of came out, but I found the decision to be kind of consistent with other conditions. But for the most part, the courts have not really, despite the travel ban, because in 2019, Justice Gorsuch kind of looked at an aggravated felony crime and wrote the majority and said, look, this is not an aggravated felony in this type of assault on a person and in other matters. So though Congress has the authority to create the law and the president has the authority to enforce it, the court is still independently reviewing that law, regardless of who appointed the judge to the court. And as an attorney and an officer of the court, and I looked at my friend Diane Eberts, who's the state bar president of the Minnesota State Bar, comment on the George Floyd trial going on, that we're, as officers of the court, we have to always we have to stand up for the rule of law. It was refreshing to look at the courts are still impartially interpreting our immigration law. Jeff, I'm going to turn it back over to you because we got 5 minutes for questions.
Thank you, Henry. And I know I'll wait to see if Nicole has any other questions that have come in as well. But one of the questions that occurred to me as somebody who just doesn't do a lot of immigration work is for, and by that I mean none, what are the things I should be aware of just as a general matter when I see people who are maybe here legally, maybe here through a proper visa, properly documented? What is the most common mistake I might make in the way I deal with them in civil or criminal matters that could put them in trouble?
In the criminal matters, you've got to find out what the person's status is. And if the person is here, let's say on a temporary H-2A farm working visa and had too much to drink in Custer and got in an argument with somebody, understanding the farm worker situation and the length of that person's stay in the United States or a student who's arrested for marijuana or maybe ingestion of something that's not marijuana will have harsh consequences. So understanding the person's status is the number one question within criminal law. And if the person's a permanent resident, and the word permanent means, hey, permanent, it doesn't if you're convicted of certain crimes. And that is something that's going to go out. Then I would say on the civil side, a person can own property and maybe be a shareholder in businesses and have equity within the United States, even if they do not have any immigration status, or maybe they have a temporary immigration status, or they have a permanent immigration status. And so understanding that person's immigration status is to start there, because that's going to allow you to discern with that client whether that person wants to intend to stay here or might says, look, I just want to invest this amount in this company. I'm going to go back to the UK or go back to Japan or go back to wherever, but I will be back in another 6 months to make sure the business is going, or for the board meeting, situations on that to understand. Okay. I don't know in the civil practice or even in the criminal practice if you look at one's social security card or not. But if a person is a United States citizen, a permanent resident, or a refugee, that social security card will not have the DHS annotation saying only valid with DHS authorization. And what happens a lot of times is when people become permanent residents from an H-1B to a permanent resident, or the college F1 student who married a US citizen spouse, they may have a Social Security card within that process of becoming a permanent resident that's got the annotation on it. But when they become a permanent resident, they need to go back to Social Security to get that card updated. So if you see that, that could be a red flag or something to at least break the ice with, Jeff.
Okay. I don't know. It doesn't appear that we have any other questions. So thank you, Henry Evans. This has been really helpful. If those in attendance have any additional questions, please contact the State Bar at info@sdbar.net, and we will get them directed to Henry. And once you leave today's webinar, you will receive a survey from the presentation, and we would really appreciate it if you would complete that and provide your feedback. It's really helpful to us. So on behalf of the State Bar of South Dakota, thank you for joining us. Thank you again, Henry, and everybody have a great day.